Hey everyone, welcome to the show. So, the DC U.S. Court of Appeals just issued a ruling that has major implications for January 6 defendants and for Donald Trump. So, at issue was the Justice Department's use of Criminal Code 18 U.S.C. 1512. That is the criminal code for obstruction of an official proceeding. Hundreds of January 6 participants have been charged with that crime, and it carries a maximum potential sentence of up to 20 years in prison. Now, it's typically been charged in cases where the prosecutor has found evidence that a defendant was planning in advance to stop the certification of the election. And most of the people who successfully made it all the way into the Senate chamber were charged with that crime, regardless of any pre-planning even, because they did stop the certification, or at least, for a period of several hours. Most notably, though, members of the Oath Keepers, also the Proud Boys, were convicted of that crime, even if they weren't at the Capitol on January 6th, even if they never entered the building, as in the case with Enrique Tarrio, with Elmer Stewart Rhodes. So Trump should be very concerned about this charge. And if the classified documents charges don't get him, if that doesn't land him in prison for the rest of his life, this very well might. The January 6th case definitely would. But the use of this statute was the subject of a lot of debate over the past 2 years. Most judges accept that this is the standard use and that it can be used in these cases. Why? Because they can read, right? And because they're not looking for an excuse to let these defendants off the hook. There was one judge, though, Judge Carl Nichols, who's a Trump appointee, by the way. He was one of the first judges to dismiss this charge. Evidently, Nichols doesn't understand the meaning of a semicolon. Okay, because he completely twisted the reading of this statute to claim that a physical document had to be involved. That these defendants would have had to have destroyed or altered an actual physical document for them to be charged with this crime. It was an absurd reading of the law, but one defendant got lucky because of this absurd decision of his. So the DOJ took this issue to a higher court. They asked them to determine once and for all if they can legally use this charge for January 6 defendants. So far, they've been given the green light by 2 courts. So far, 2 courts now have said, yeah, Judge Nichols doesn't know what he's doing. As I mentioned in the beginning, a 3-judge panel for the U.S. Court of Appeals in the District of Columbia just granted a stay on a lower court's opinion that, yes, the DOJ is correct in their use of 18 U.S.C. 1512. So this case will now move on to the Supreme Court. They can decide if they want to or if they don't want to take this case up at all. So far, they've been reluctant. They've been reluctant to weigh in on matters involving these January 6 cases, also the 2020 election. So we'll see. I mean, everything rests in their hands. But if I was Trump, I would be very nervous right now. Clearly, the special counsel is not afraid to pull the trigger on an indictment against a former president. And this charge would be perfect because just as with Stewart Rhodes, just as with Enrique Tarrio, he masterminded so much of what happened on January 6th. So anyway, guys, I'll keep you posted. Thank you so much for watching and listening. Please like this video, share it with everyone you know, become a subscriber if you have not already. It really helps with the algorithm. It really helps to get more eyeballs on this important information. So really appreciate it. And if you can donate, that also helps to keep the show going. Greatly appreciate all of you. Love you all. Take care, and I'll talk with you soon.